ROC 2012 states that once a writ of summons has been served to the defendant has 14 days after the service to enter into appearance. Failure to enter into appearance by the defendant could result in a judgment in default against the defendant according to Order 13 of the ROC 2012. The decided case is an appeal case against the decision of the Sessions Court, which had dismissed the application by the appellants to set aside the judgment in default of appearance after a full trial. The appellants filed an application to set aside the JID 9 months after the JID was obtained against them. The subject matter in this case involves liquidated sums arising from a friendly loan agreement between the appellant and the respondent.
Today, madam, is Jenny here to talk about the mode of service. In Order 10, Rule 1, Paragraph 1 of the ROC, the law accepts the service of originating documents, such as read, can be done through prepaid AR register post. If the service is effected but the defendant does not appear into the appearance, Order 13, Rule 7 of the ROC empowers the plaintiff to apply for GDA with the need to show proof of service of read. In determining whether a service through a AR register post is regular, there are two perspectives. From the earlier years of case precedent, the court will invoke the presumption under Section 12 of the Interpretation Act, presuming that a service is effected when a document is posted. The case of Yap Ki Huat supported this position, where the court in this case declared that the act of posting is prima facie proof of service. Even if the acknowledgement card was not written, the service will still regular and effective. However, recent development provides a contradictory view where the court requires an acknowledgement card to be written. This is shown in the case of Ali bin Jaman, whereby the court ruled that non-written of the card will amount to a non-delivery of the writ, while the court in Chong Wyman necessitated the AR card to be exhibited in the affidavit of the service to prove service is effected. And in the recent landmark case of Goh Teng Wu, the federal court even established that acknowledgement of receipt of an AR card is compulsory to be exhibited as a conclusive proof of service. In our review case, the court followed the precedent of the earlier years, which upheld the principle that mere proof of posting is sufficient to establish the act of service. The court also relied on Section 12 of the Interpretation Act to presume the appellant had received the writ, regardless if it is physically handed to them. In the court's opinion, since the ROC does not legislate any requirement on this, the service should be held as regular. But if this case is placed before the current development, the service would be irregular because in Goh Teng Wu case, failure to provide an acknowledgement card and refusal to expand on the non-production is sufficient to rebut the presumption of service under Section 12 of the Interpretation Act.
Order 13 of the ROC states the ability to obtain a judgment in default of appearance of writ. However, the court may set aside such judgment in accordance with Order 13 Rule 8 of the ROC. Order 42 Rule 13 of the ROC then states the time limit for the applicant to serve the application to the responding party. There are two grounds which allows the defendant to apply to set aside a judgment. The first ground is seen in the case of S.A. Andavan, which states the ability of the court to discharge irregular orders. The second ground is derived from the case of Barnes, where an applicant must show that the defense has merits in the case being an arguable and triable issue. The court should not interfere with the judgment when all matters and merits were already been considered by the former court according to the case of Bank Bumi Putra Malaysia Berhad. The appellants seeking to set aside the GDA needed to prove that first the JID was irregular and that they had merit to their claim. The High Court in the present case addressed three issues raised in this case. The first issue being the lapse of time to apply for setting aside judgment. There was a non-compliance with Order 42 Rule 13 of the ROC. This is also in reference to the case of PT Pelajaran Nasional Indonesia and the case of Tuan Haji Abdul Rahman. The second issue is regarding the irregularity of the judgment order. The court ruled that the service via AR registered post was in compliance with Order 10 Rule 1 of the ROC. And in the case of MBF Finance Berhad, the service of AR registered post is a prima facie proof of service. The third issue is on the merit of the defense. The contention made was that the judgment sum was incorrect and the money lending transaction was actually illegal. However, the court found that the contention did not stand as the appellants did not own a money lending business. That is all for the issue on whether the judgment in default obtained against the appellant should be set aside.
To sum up for this case, the court opined that producing proof of service via AR register post is sufficient to constitute effective service. Therefore, JIDA was regularly obtained. Alternatively, if Goteng Wu's position is followed and thereby the service becomes irregular, the failure to comply with the 30 days rule and lack of defense of merit will also disentitle the appellant's application. With that, JIDA in this case remain regular and effective. Next, I will pass the floor to the next case.
Second case that we picked for our case review is the case of CapAsia against Sun Energy Solar, which touch on the application of summary judgment that can be under Order 14 and Order 81. Order 14 may bring an action by applying summary judgment against the defendant who has no defense to a claim and that has been served with the statement of claim, while Order 81 is in regards to the specific performance matter. The plaintiff may straightaway file the application under this provision. Well, in this case, the plaintiff and the defendant have a master investment agreement to provide equity funding. First and other defendants signed the guarantee and indemnity and executed a memorandum of deposit of share, providing the plaintiff with a security over the ordinary shares of the second and fourth defendant. The plaintiff files suits against the defendant for breaching its material obligation, wrongful delusion of the second and fourth defendant, stake in the third defendant, and failure to pay installment to the plaintiff. The plaintiff asserted he had indirect interest in the solar project and was entitled to a specific performance due to the unpaid balance of the first defendant. The judge of the High Court denied summary judgment because the defendant prevailed in arising a few tribal issues, thereby dismissing the application with a cost that will be borne by the defendant.
Now we will move on to the next part, which is the supporting provisions and case. The first matter will further discuss on the preliminary requirements stated under Order 14 of the Rules of Court 2012. Under Order 14, it has listed the three preliminary requirements that the plaintiff is required to satisfy before filing summary judgment application. The three requirements are: the statement of claim must have been served to the defendant must have entered into an appearance, and that the plaintiff may file the summary judgment application on the ground that the defendant has no defense against his claim except in the amount of damages claimed. There are two cases that further affirm on this matter, but the case of National Company for Foreign Trade against Kayu Raya Sendirian Berhad has further affirmed that in every application under Order 14, the first consideration is whether the case comes within the scope of Order 14 and whether the plaintiff has satisfied all the preliminary requirements for proceedings stated under Order 14. Next is Order 81 of the ROC 2012. Although Order 14 is the general application of summary judgment, there are few other orders that could be used to apply summary judgment, which one of them is Order 81. Order 81 specifically caters on the claims for specific performance or rescission of agreement. It has been stated under the case of Mawar Awal M. Sendirian Berhad against Kepung Management Sendirian Berhad and another that Order 81 shared the similar procedural objective with Order 14, which is to provide for speedy mechanism without going through trial. However, we are able to come up with few point of differences to point out the difference between Order 81 and also Order 14. So there are few points of differences between Order 81 and also Order 14 in terms of the requirement of the defendant's appearance, the time limit, the affidavit of support, and also the minutes of judgment required. So that's all from me. I'll pass to the next presenter.
Next, moving on to the second issue that can be raised by a defendant in rejecting a summary judgment, where a defendant may raise a question on one of the 6 technical objections such as delay in rejecting a summary judgment, even though it is known as a non-compliance with the rules. According to the principle established in the case of Krishnamurti, the plaintiff must file the motion prior to defendant filing its defense. But if the plaintiff filed it after the defendant has entered its defense, the plaintiff must give justification on its delay on the application of summary judgment. And one of the cases that illustrate where court accepted the justification is that in the case of CGIR against Wangkok Mining, where the court accepted the justification on the delay due to the holidays and fasting months, hence not dismissing plaintiff application on summary judgment. A delay also can be allowed to when the learned judge exercises its power under Order 14, Rules of Court, which by referring to the case of Jacobs, in order to put an end to the state affairs and prevent current defenses from defeating the rights of parties. Moreover, as laid down in Jones' case, summary judgment can be applied if there is no doubt that the plaintiff is entitled for it, and it would be inconvenient for the defendant to storm merely for delay's sake. Aside from that, in Southern Finance Berhad case, the court upheld that once the summary judgment application is made, the defendant has right to defend. I think that's all from me. Thank you, and let's move on to the next presenter.
Basically, the plaintiff has a prima facie case when satisfied the preliminary requirements, and now the burden is shifted to the defendant to prove that why the court shouldn't give the summary judgments. For instance, the defendant can raise the tribal issue or the question of law under Order 14, Rule 3, Subsection 1, and Order 18.1, Rule 3. What is tribal issue? Referring to the Ghazali case, is when the defendant has merits and good defense, difficult point of law or dispute of fact to be tried. For Order 14, let's look at an Singh case. When there's a great variations in the appearance signature in the documents and the specimens, it's a tribal issue. For Order 18.1, in Allied Automotive case, it's tribal for the matter of variations and estoppel because liability for the breach of contract is not clearly established here. But if it is a bare denial of the fact or an inarguable question of law, the court will proceed to the summary judgment. Under Order 14, Rule 3, Subsection 1, there is some other reason for trial. It refers to the circumstances that ought to be investigated. It's an alternative if the defendant failed to raise any tribal issue or technical objections. In Miles v. Ball, the husband resold his farmhouse with a lower price. For justice, the court granted leave of defense for the wife as plaintiff control most of the relevant facts.
So we'll move on to the analysis on application of civil procedure, especially on the preliminary requirements part under Order 14 and also Order 81. In this case, it has been contended by the defendant that there is an issue of time frame of the application of summary judgment done by the plaintiff. However, it is clear that time frame is not one of the preliminary requirements that were required by the plaintiff to satisfy before filing the application. Therefore, it is proven that plaintiff has satisfied all the preliminary requirements and that the consideration stated under the case of National Company for Foreign Trades has been satisfied. Under Order 81, there is no dispute as to the fulfillment of any preliminary requirements under Order 81. However, the burden is on the defendant to raise any triable issue in order for the application to be dismissed.
Although, as per discussed earlier, the general rule allowed a delay in filing the application for summary judgment, in the present case that we are reviewing, the learned judge rejected the defendant's contention that a delay affected the application of summary judgment from the plaintiff. The learned judge further supported its rejection by referring to the case of Perkapalan Syamrin Jaya that stated that a delay is not a basis for denying plaintiff's right to summary judgment in the absence of a real defense. So that's all for the issue on technical objection such as delay. Let's move on to the next presenter.
The defendant has successfully raised several tribal issues. In the earlier, the issue of whether the plaintiff's breach has been remedied, the variations of the terms which require the full trial and the witness examinations to see its true nature, as stated in the Kim Hwa holdings. Next is tribal for the issue of afterfur and the construction of the documents like memorandum, which resort to the clear intention and bargain. Citing the Southeast Asia case, the defendant has more than one tribal issue and thus satisfy the low threshold to resist the summary judgment. Citing UMBC Berhad case, for the interest of justice, the present case requires further investigation on whether the breach is adduced by the plaintiff's own case and is proper and fit to invoke some other reason for trial under Order 14, Rule 3, Subsection 1. In this case, the plaintiff has fulfilled the preliminary requirement for the application for summary judgments. Although the issue of delay cannot be raised as a sole ground, the defendant has successfully raised several tribal issues or at least some other reason for trial. Hence, the court is correctly in dismissing the application for the summary judgments. Thank you. That's all for us.